Welcome to The Explainer. I am absolutely thrilled to have you here today because we're embarking on a real, rigorous, university-level constitutional deep dive. We're looking at one of the most significant and, frankly, most hotly debated pieces of legislation in modern British history. We're talking about the Human Rights Act, 1998. We're going to unpack exactly how this act incorporated the European Convention on Human Rights right into domestic law. We'll examine how judges are constantly balancing our individual rights against competing public interests. And of course, we'll explore the intense, ongoing political debate about the future of this legislation. We have a ton of ground to cover today, so let's get right into it.
Okay, let's dive into this with a rather provocative quote from back in 1998. It claims the convention made a clandestine entry into British law by the back door. See, before the Human Rights Act was passed, the European Convention on Human Rights, or the ECHR, wasn't actually a direct part of domestic UK law. But it still somehow managed to exert this heavy, almost secretive influence on judicial decision-making. Basically, this legal maneuvering was a really unsatisfactory halfway house for everyone involved, and it completely set the stage for a massive constitutional shift that would eventually swing that front door wide open.
So here is our structural roadmap for today. First, bringing human rights home. Second, the mechanics of the act. Third, the Judicial Balancing Act. And fourth, the ongoing political debate.
Section 1. Bringing human rights home, from Strasbourg to the UK.
To truly appreciate the mechanics of the 1998 legislation, we first need to understand the historical problem it was explicitly designed to solve. For decades prior to the Act, the UK was a signatory to the European Convention on Human Rights. But those rights just weren't directly enforceable in domestic courts. Imagine this. If you were a UK citizen and your fundamental rights were violated by the state, you couldn't just pop down to your local court to get it sorted. You had to take the painfully slow, exhausting, and incredibly costly route all the way to the European Court of Human Rights in Strasbourg, France. As the House of Lords later pointed out, the main purpose of bringing the convention into domestic law wasn't necessarily to give victims better remedies. It was to give them the exact same remedies, just without the immense delay and massive expense of that journey to Strasbourg.
Section 2. The mechanics of the Act. How the HRA functions in court.
Let's move to and see how this builds into the practical application of the law. Rather than a strong incorporation like you'd see with EU law, the Human Rights Act uses a weak, or let's say more nuanced method, mostly to preserve parliamentary sovereignty. For instance, Section 2 requires UK courts to take into account Strasbourg judgments. That means they aren't strictly bound by them, though, they usually do follow them. Section 3, that's the real powerhouse. It requires all legislation to be interpreted compatibly with convention rights. Section 4 allows courts to declare a law incompatible if that interpretation fails. Section 6 forces public authorities to act compatibly, while Sections 7 and 8 allow victims to bring proceedings and empower courts to grant just and appropriate remedies. Put them all together, and these sections weave human rights seamlessly into the domestic legal framework.
Now, what's really interesting about this slide is how it highlights the delicate constitutional balance between the judiciary and the legislature. Look at the sheer friction between Section 3 and Section 4. Under Section 3, courts have this radical power to creatively interpret or read down statutes. A famous example is Gadan v. Golden Mendoza. Here, the House of Lords interpreted the words wife or husband in a housing statute to include same-sex partners to prevent discrimination. Lord Nichols famously said the court must literally bend the meaning of the legislation as far as possible. But, and this is absolutely vital, if bending the law fundamentally breaks its underlying intent, the court has to step back. That's where Section 4 kicks in as a measure of last resort. The court issues a declaration of incompatibility. They explicitly say, hey, this law violates human rights, but they leave it entirely up to Parliament to actually change it.
So if Section 3 is all about the laws themselves, Section 6 is the enforcement engine against the state. It creates a very strict framework of accountability, making it unlawful for any public authority to act in a way that's incompatible with the convention right. And this covers a massive range of actors. We're talking the police, the NHS, local governments, and crucially, even the courts and tribunals themselves. If a public authority fails this duty, Section 7 steps in to ensure that the victim of that unlawful act can drag them right to court.
And we really have to remember that the public authorities we just mentioned, like local councils and housing planners, the decisions they make deeply impact everyday life and human rights. Let's look at a pressing modern issue where this plays out: urban housing. As global urbanization accelerates, public authorities are constantly having to manage the rapid densification or intensification of housing. This whole push toward high-rise vertical living and smaller, tightly packed homes, it creates massive new challenges for social justice and public regulation.
Just look at the complex regulatory decisions public authorities face on this front. It's like a giant puzzle. Over in Ireland, authorities are debating the demographic merits of small homes policies. In the UK, research shows that inequalities in housing space and overcrowding tragically contributed to much higher COVID-19 infection and mortality rates. Local planners are constantly having to balance expanding city borders against protecting sacred areas, like the boundaries of the New Forest. They're also applying things like the nationally described space standard to prevent what experts call territorial injustice, which is where adequate housing space in one area is deemed totally unacceptable in another. Even regulating purpose-built student housing requires planners to weigh the rights of students against global real estate investments. In all these scenarios, the state is forced to balance broader community needs against fundamental individual rights, like your Article 8 right to respect for a private and family life. And let me tell you, that is no easy feat.
Section 3, the Judicial Balancing Act, Proportionality and Competing Rights.
Because human rights, for the most part, are rarely absolute, they routinely require judges to weigh competing public interests in the courtroom. When the state tries to justify interfering with a citizen's qualified right, courts apply the doctrine of proportionality. The Supreme Court codified this in the Bank Milad case, creating a rigorous four-step formula. And this brilliantly illustrates exactly how judges objectively make that call. Step 1. Is the state's objective sufficiently important to justify limiting a right? 2. Is the measure rationally connected to that objective? 3. Could a less intrusive measure have been used? And finally, looking at the severity of the consequences, has a fair balance been struck between the rights of the individual and the interests of the community? This formula ensures the state can't just trample your rights in the name of the public good without a highly structured, solid justification.
But what happens when two different human rights collide head-on? For instance, the Article 8 right to privacy versus the Article 10 right to freedom of expression. In the famous Campbell case, which involved a high-profile celebrity and a newspaper, Baroness Hale noted that judges actually have to look at the comparative importance of the specific rights being claimed in that exact scenario. They assess the justifications for restricting each right and apply that proportionality test we just talked about to both of them. So they might find that political speech deserves the absolute highest protection, whereas revealing the intimate medical details of a celebrity's private life attracts far less protection. It is a meticulous, case-by-case balancing act.
Now, this brings up a fascinating nuance of the act called the horizontal effect. We established earlier that only public authorities can be directly sued for breaching the Human Rights Act. You can't just directly sue a private newspaper or an employer under it. However, because the courts themselves are defined as public authorities under Section 6, they actually have a duty to act compatibly with convention rights. This means that when a judge is deciding a case between two private parties, say a breach of confidence claim against a newspaper, that judge must develop and apply the common law in a way that inherently respects and protects human rights. The rights effectively ripple out horizontally into private litigation. Section 4. The ongoing political debate, rights versus sovereignty. So, zooming out from the courtroom, the Human Rights Act has generated massive macro-level political friction since its inception. And a lot of it is centered around this perceived shift of power from Parliament to the unelected judiciary. So the crucial point is perfectly captured right here by Lord Nichols. Even though judges try their hardest to make laws compatible, there is a hard constitutional boundary. Parliament deliberately retained the right to enact legislation that violates human rights if it explicitly chooses to do so. This reveals that both judges and politicians remain incredibly sensitive to the exact line where judicial interpretation ends and parliamentary sovereignty begins. But for some politicians, the act still gives judges way too much leeway. And that tension has led to a sustained, ongoing political debate, which we can map out quite neutrally here. Historically, the Conservative Party argued the act diminished Parliament's power. Back in 2009, then opposition leader David Cameron proposed replacing it with a British Bill of Rights. Those plans were kind of shelved during the 2010 coalition government. Fast forward to 2021, and the government-commissioned Independent Human Rights Act Review, or IHRR, actually reported that the act was a success, suggesting only very modest changes. Despite this, in 2022, the government moved forward anyway and introduced the Bill of Rights bill to Parliament, seeking to repeal and replace the 1998 Act entirely. So, what exactly did that 2022 Bill of Rights bill propose? Interestingly enough, it would have retained the exact same ECHR convention rights, and it maintained the requirement for public authorities to act compatibly. However, it sought to introduce a new permission stage. This meant claimants would have to prove they suffered a significant disadvantage before even getting their human rights claim into court. The government's explicit aim with this bill was to limit the sheer volume of claims, curb alleged judicial overreach, and officially restore the balance of power back to the legislature. The debate over the Human Rights Act represents a fundamental tug-of-war right at the heart of the UK's constitution. Look, the legislation successfully brought rights home, it created incredibly powerful tools like the Section 3 interpretive obligation and the Bank-Malott proportionality test, and it forever changed the daily duties of public authorities. Yet that political friction remains. So, as you reflect on everything we've covered today, I leave you with this final profound question to consider. Where does the ultimate balance truly lie between strongly protecting individual fundamental human rights and preserving the unyielding sovereignty of Parliament? It is an ever-shifting equilibrium, and honestly, understanding it is absolutely key to understanding modern constitutional law. Thank you so much for joining me on this explainer, and keep exploring.